Great, so we're going to go ahead and get started. My name is Amanda Gerke. I'm with the City of Alameda's Community Development Division, and this is the California Employment Law Update, what every employer needs to know as we head into 2021 webinar. So I'm going to do some introductions in a minute, but first, just a few technical notes. First of all, we have all of the attendees on mute so we can make sure to hear what our speaker is saying. If there is something you need to communicate to us, a technical issue, you can definitely use the chat function to chat with staff, but we're not going to be taking questions through the chat function. If you do have a question, we ask that you submit it through the Q&A function at the bottom of the screen. So we're going to take questions through the Q&A function, and then if we have time at the end, we will go through questions. We're also going to be recording this presentation and posting it on our website. So I'll be sending you all a follow-up email with a link to the recording, as well as any other resources that come up on today's call. Our presenter is interested in sending some follow-up information to you all via her mailing list. So if you do not want to be included in her mailing list, please send me an email by the end of the week and let me know, and I can opt you out. I will put my email address in the chat function if you do want to opt out. And finally, I just wanted to say this chamber is being brought to you by a partnership between the City of Alameda and the Alameda Chamber of Commerce. So I'd just like to take a minute to introduce Madeline Sadek, who is the President and CEO of the Alameda Chamber of Commerce. We also have other city staff members in attendance, Eric Fonstein and Lois Butler. So with that, I'd like to introduce our presenter today. Shivani Sutaria is an employment law attorney and workplace investigator, and the founder of Shivani Sutaria Law Offices in San Mateo, California. Her practice focuses on external workplace investigations, providing advice and counsel to employers, and presenting trainings on employment matters such as this. So with that, I'm going to turn it over to Shivani to begin the presentation.
Okay, thank you, Amanda. Hello, everyone. I know I can't see you, but welcome to this seminar, and thank you for joining us. As I'm assuming most folks on this webinar are employers, and I'm hoping that the information that I'm going to share with you is going to be helpful as you prepare for 2021. As you probably know, as being employers in California, every year in the fall, the California state legislature starts passing a lot of laws, and there's always a ton of employment laws. And as you can imagine, many of the newly passed bills that have now become law, signed into law, are related to issues of COVID-19 and are also some related to different kinds of leave of absences, discrimination, and so on. So what I've done is selected some, not all, of the new employment related laws that have been passed in California. I'm also going to highlight in the presentation a few court cases. One regulation that was passed just days ago regarding COVID-19 by OSHA, as well as giving you some reminders, some to-dos that you need to take care of before the new year starts, or as an FYI, as the new year starts, about some other matters that have that were passed a while ago, not just in this last session. So I am going to be going through a PowerPoint presentation. So I'm going to screen share now. Let's see. Okay. All right, California Employment Law Update, what every employer needs to know as we head into 2021. I always put this disclaimer on my PowerPoints, which is that this is for informational purposes only. This presentation does not constitute legal advice or establish an attorney-client relationship. And again, because we only have an hour, I'm going to be highlighting some of the major points of these different laws, but I will not be able to go through every detail of them. So if you have follow-up questions, please feel free to get in touch. All right, so let's start with a slew of the new COVID-19 related bills. I'm trying to put this somewhere, so, okay. All right, SB 1159. This is in relation to COVID-19 and workers' compensation coverage. This is going to apply to employers with 5 or more employees. And what this bill does is actually mirror an executive order from Gavin Newsom that was earlier in this year, but expired in mid-July, which was saying that if an employee gets COVID-19, there was a presumption that they contracted the virus at work. So that expired back in July, but now with this new law, it is putting that presumption back in place. So what it says is that there's a disputable presumption that employees who suffer illness or death due to COVID-19 contracted the virus on the job and thus is compensable through the employer's workers' compensation insurance. Now, this is going to apply really to employees who are at the workplace. So for those who are working from home, this is not going to necessarily apply. It's going to be if you're going into some sort of a workspace. Now, the employer can dispute this presumption, and there's a few ways to do that: to show evidence that the employer had measures in place to reduce the potential transmission, the employee's non-occupational risks of infection, meaning that they were in some type of a job where they really did not have much of a risk of infection. Any sort of statements made by the employee, such as, oh, I went to a family party and there were multiple people who had COVID-19 there and I contracted it soon after, something along those lines. Or any other evidence normally used to dispute a work-related injury. This is just a catch-all. If there's any other information the employer can share to show that the employee, in fact, did not get COVID-19 at work. Now, let's say that an employee did get it at work. The employer now has certain reporting requirements to their workers' compensation insurance claims adjuster, which needs to be done in writing within 3 business days. And this is so that claims administrator can determine if there is going to be an outbreak or there is an outbreak at that workplace. And so the information you as an employer need to provide to the claims adjuster is that an employee has tested positive, the date the employee tested positive, the address of the workplace of where that employee was working for the past 14 days, as well as the highest number of employees who were working at that same job site in a 45-day preceding period. And so this bill actually has some teeth to it, because it says that if an employer fails to provide this information to their workers' comp insurance claims adjuster, they can face a $10,000 penalty for failing to report this information or for providing false or misleading information. So this bill is effective immediately, went into effect already as of September 17th, 2020. And but goes back to employees who contracted the virus from July 6th and on. And this bill is in effect and through January 1st, 2023. All right, another COVID-19 related bill, mandated reporting of COVID-19. So employers, if you have an employee who tests positive or is even has potential exposure to COVID-19, within 1 business day, you now have the affirmative duty to let other people know. And when I say other people, specifically, to let your other employees know, to let the employers of subcontracted employees. So if you have like any temps, you would need to let the temp agency know, as well as employees' representatives, for example, if they're part of a union. And when you provide this notice, you must include information about the fact that there was possible exposure, any sort of COVID-related benefits that are available, so things like paid sick leave, as well as what the employer's policies and protocols and plan is for safety, sanitation, disinfection, in an effort to eliminate any sort of further exposure. Okay. And also, employers have an affirmative duty to notify their local public health department if there is an outbreak, and they must do this within 48 hours. Now, how an outbreak is defined is actually going to vary based on the type of business or industry one's in, but that information can be found on Cal OSHA's website. And what in doing these things, if you're investigated ever by Cal OSHA in regards to a COVID-19 matter, you would need to show that you in fact complied with this law. You gave notice, as well as any sort of information that you provided to your employees. And if you don't, you could face citations. So this takes effect starting January 1st, 2021. Another one. So if many of you probably have heard, since April 2020, there was the federal expansion of paid sick leave, as well as expanded family and medical leave. That's called the Federal Families First Coronavirus Response Act. Now, if you recall, that applied to employers with 500 or less employees. So what California has done now with AB 1867 is to provide the similar requirement on large employers. So if you're an employer with 500 or more employees, you now have the same requirements about paid sick leave and expanded family and medical leave. This also went into effect upon signing September 9th, 2020. And just like the federal act, it will expire at the end of this year, but with the possibility of renewal or extension. So this is not a law. This is regulations that were passed just days ago. So this is coming from Cal OSHA, and they passed what is called COVID-19 Emergency Temporary Standards. This applies to most California employers. And what the requirements are here is that every employer needs to have some sort of a written prevention program for COVID-19. Now, if you, again, are an employer in California, you probably have already complied with something very similar, which is having a written injury illness prevention plan. So this is very similar to that. In this COVID-19 prevention plan, you need to identify and evaluate employee exposures to COVID-19 health hazards, implement policies and procedures to correct unsafe and unhealthy conditions, how you're providing PPE, and how you're providing training. These standards also have certain requirements related to notification, testing. So for example, there is a requirement that employers need to pay for testing, COVID testing, if they're requiring it, as well as some record keeping requirements. So what I've done here is provided the links for a frequently asked question document that just came out through the Department of Industrial Relations, as well as a link to a one-page fact sheet. And on that fact sheet, there is a link that takes you to a model prevention program. So it's like a written document that's a template, and you fill in the information for your particular business, and that can be then converted into this COVID-19 prevention program. This went into effect upon being implemented on November 30th, 2020, so about a week and a half ago. All right, so I am now moving to leave of absence related bills. So we're out of COVID-19 now, and we're in leave of absence related bills. And so this is the biggie. This really is a game changer for small businesses. So you probably have heard of the federally the Family and Medical Leave Act, and the California equivalent of that, which is called California Family Rights Act, CIFRA, FAMLA, CIFRA. Probably sounds familiar. Well, if you remember, both of those laws applied to employers who had 50 or more employees. What this is now doing is decreasing applicability to employers with 5 or more employees. 5 or more, okay? And so in terms of which employees would be eligible, it is going to mirror the previous requirements, which is that that employee needs to have worked at least 12 months at your place of business and worked at least 1,250 hours in the previous 12-month period. What this new version of CIFRA does is eliminate this two previous requirements. One was that you needed to work with 50 or more employees working within a 75-mile radius. So what that meant was if you had a company previously that was headquartered in San Francisco and you had one person down in Southern California, they were not going to be eligible. This new bill eliminates that requirement. So really, any of your employees could be eligible. What the previous bill had was an exemption for your employees who were at the highest 10% in salary, and that's also been eliminated here. So what rights does CIFRA give an employee? It gives them up to 12 work weeks of unpaid protected leave during any 12-month rolling period. And that can be 12 work weeks of consecutively, or 12 weeks that can be taken intermittently, again, based on need. And what are the reasons for the leave? 1, baby bonding, to bond with a child that is newly born, adopted, or placed in your home as a foster child. And the leave needs to occur within the first year of this event of the child being born or adopted or placed in your home. And the reason that next bullet point about parents who are employed by the same employer can each take up to 12 weeks of leave for baby bonding. That's in red. So everything in red is what's different with this new version of CIFRA than it was from previously. In the old version of CIFRA, if you had 2 parents working for the same employer, they couldn't each take 12 weeks. It was combined. Now each parent can take up to 12 weeks of leave for baby bonding. Oops. Some more information here on CIFRA. Okay, so baby bonding, that's one of the reasons you could take it. Another reason, if you have a serious health condition that makes you unable to perform your job functions. And then also you can take this leave to care for an immediate family member who has a serious health condition. In terms of who are the covered family members under this law, it is going to be employee's parent, child, and spouse. And now in red are the ones that have been added on. So this is different than before. It also includes registered domestic partners, a grandparent, a grandchild, and sibling. And lastly, another reason you can take a leave, which is new to CIFRA, but always existed in FAMLA, the federal act, is for a qualifying exigency related to covered or call to covered active duty of an employee's spouse, domestic partner, child, or parent that is in the U.S. Armed Services. So a few things to just note about CIFRA is how it interacts with some other existing laws. So if you are an employer who has 5 or more employees, Previously, you already had California's pregnancy disability leave law applying to you. What that law is for a pregnant woman who is going to be disabled either during pregnancy or after childbirth. And that law provides the woman with 17 and 1/3 weeks, which is 4 months of pregnancy leave related to any sort of medical conditions that arise due to pregnancy, childbirth, or related issues. So what that means is that under CIFRA, a pregnant woman can first take these 17 and 1/3 weeks of leave. And then after that's done, they can take the baby bonding leave under CIFRA. So you're looking at almost 7 months of protected leave that an employee could possibly take. Now, both are unpaid, while an employee can get some state benefits, either temporary disability benefits through the EDD or the paid family leave benefits. It's not for the whole 7 months. The paid family leave benefits is now for 8 weeks, and the temporary disability benefits vary, but usually it's 6 to 8 weeks. So that's one thing to note. The other thing to note is if you are an employer who has 50 or more employees, and so you have CIFRA, but you also have FAMLA that you have to comply with. That's the federal one. Now, while most things are most reasons for why you can take it are the same, there are a few differences, excuse me, which is that CIFRA, for example, allows you to care for a grandparent or a sibling who has a serious health condition. FAMLA does not have that. So what that possibly means is that you can have an employee who takes 12 weeks off to care for a grandparent or a sibling, and separately can take FAMLA leave to care for themselves, or let's say a parent, or for baby bonding. So there is a possibility that that an employee could have can be eligible for both and take both for different reasons. This law becomes effective January 1st, 2021. All right, this is another leave law. So this has to do with expansion of an existing law. As you may know, there has been an existing law in place for several years in regards to providing protected time off to victims of domestic violence, stalking, and sexual assault. What this bill does is add to that. It adds victims of crimes or abuse. So that means if an employee is a victim that caused them physical injury or caused mental injury and a threat of physical injury, they would be eligible for this type of leave. Or if they have an immediate family member who is deceased as the direct result of a crime. So it's expanding on that. Just like previously, what this law says is that an employer cannot fire, discriminate, or retaliate against an employee who takes leave for one of these reasons. In terms of what the employee can take leave for, it varies based on how big you are as an employer. So for any employer who has one or more employee, if you have an employee who needs to take this leave, then they can take it for the purpose of attending a judicial proceeding or obtaining judicial relief. Like if you need to get a temporary restraining order, for example, or you need to testify in court against someone. That applies for to employers with one or more. If you are a larger employer and you have 25 or more employees, then there's many more reasons for why you could take this protected leave. This includes medical attention, if you need to get medical attention, if you need to obtain services from a shelter, a program, a crisis center, if you need psychological counseling or some other type of mental health services, or if you need to do some sort of safety planning for yourself or your family. In terms of what an employee needs to provide you as an employer in the form of certification, it is all going to be typical things that you can imagine, like a police report or maybe a document from their doctor. But the one that I wanted to highlight is the new one in this bill, which is now what can suffice as certification is simply a written statement signed by the employee or an individual acting on the employee's behalf, certifying that the absence is for the purpose covered under this policy. So an employee who needs this leave doesn't necessarily need to go get a police report or one of those more official or formal types of certification. They can themselves just write a statement and sign it and provide that to the employer saying they need this leave. This is effective January 1st, 2021. All right, this is AB 2017. So there's, as you probably all know, California paid sick leave, which one can take to, if they have their own sickness or illness, but also to care for a family member. And sometimes this is called kin care, caring for your kin. What this bill does, it doesn't change really anything substantive, but it clarifies that the employee, not the employer, has the sole discretion to designate which days they're taking off under their California paid sick leave as kin care. And this is because under existing law, employees can use up to half their paid sick leave to care for a family member. So what the reason for this bill is what was happening was, and the employers were saying, we're designating, okay, an employee's taking time off, they're caring for a family member, we're going to designate it as such. It's more than half, they've taken too many, they've taken more than half their days for this purpose, and they don't have any more. And this just takes it out of the hands of the employer, since obviously the employee knows better in terms of why they're taking paid sick leave. And so it is the employee who now needs to designate if their sick day is for caring for a family member. This is effective January 1st, 2021. All right, so we are now moving on to another category, which is discrimination and equal opportunity related bills. SB 973, this is in regards to reporting pay. So again, this is going to be applicable to larger employers. If you are an employer with 100 or more employees, then you already have been filing with the federal government to the EEOC your EEO-1 report. It's the Equal Opportunity Report, where you are submitting information about the number of employees that you have based on their race, ethnicity, and sex as they fall into 10 different broad job categories. And so back in 2016, when we were still under the Obama administration federally, there was a new requirement that rolled out, which was that employers also had to provide similar information based on race, ethnicity, and sex in these 10 job categories, but not just to provide how many employees do you have total in these categories, but actual pay data. How much are they earning? And so when the Trump administration came in 2017, they halted this requirement on the federal front. And so this pay data is not being reported for the last many years. So what California has done here is reinstitute that for California employers. So if you're a California employer with 100 or more employees, you now need to submit pay data to California's Department of Fair Employment and Housing. And specifically what you need to provide is information on the number of employees in 12 different pay bands or pay ranges for 10 different, the same 10 different job categories by race, sex, and ethnicity. And so what they're requiring under this bill is for an employer to look back in this year, 2020, for a snapshot of one quarter. And so this would be October 1st through December 31st. and to report information, pay data information for that period, but then to also calculate it for how much that would mean for annual earnings. So employers must submit this first round of data by March 31st, 2021, and then March 31st each year thereafter. And if you look on California Department of Fair Employment and Housing website in regards to this, they have put out informational, frequently asked questions and fact sheets about how to comply with this. Oops. Okay. SB 979. This is in regards to public companies. So if you're a publicly held corporation, this is going to apply to you. And it is about diversifying your board of directors. So again, if you go back to last year, the year before, there was a similar bill that came down in California that required also publicly held corporations to diversify their board by gender. So what this is doing is asking employers, well, requiring employers to diversify their board of directors for race and sexual orientation. So what it says is that they must diversify their boards from underrepresented communities. That's the language used in the bill. And the way that is defined is by race: Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, as well as by sexual orientation, gay, lesbian, bisexual, or transgender. And so the requirements here are that by end of next year, so December 31st, 2021, a publicly held corporation must have one director from one of these underrepresented communities. And then by December 31st, 2022, so 2 years from now, if it is a board of directors that have 5 to 8 directors, then at least 2 must be from underrepresented communities. If they have 9 or more, then at least 3 directors need to be from these underrepresented communities. There is fines for non-compliance ranging from $100,000 to $300,000, obviously very significant. So something to pay attention to. Okay, this is AB 1867, which is actually a bill that I talked about in the beginning related to COVID, but snuck into that COVID bill is this other piece that actually has more to do with discrimination, which is that the DFEH, so that would be the Department of Fair Employment and Housing, which is California's agency that adjudicates discrimination and harassment issues, is establishing something called the Small Business Family Leave Mediation Pilot Program. And what this does is establishes a mediation program through the DFEH for small employers. So that's being defined as having 5 to 19 employees, and to help an employer resolve issues with their employee based related to family leave discrimination issues. So as you can imagine, this year in particular, with COVID-19 and shelter in place and businesses having to shut down, furlough employees, lay off employees, there's been a lot of hard decisions that employers have had to make in terms of how to comply with that, decisions on who to bring back, why, when, and so on. And as a result, there's a lot of confusion, and that has led to litigation on family leave discrimination issues. And so what the DFEH is trying to do is see if they can help resolve these issues through mediation between employers and employees prior to the employee getting a right to sue notice and then filing a discrimination case in the courts. This is a pilot program. And so it goes into effect January 1st, 2021. All right, so this is another big one. We are out of the discrimination EO category, and now we are into independent contractors, AB 2257. And we could probably spend an entire hour just talking about this particular leave law. I actually had done a webinar for the San Mateo Arts Commission where we talked for an hour just about this particular new law because it really impacted the arts music industry. So everyone knows AB5. AB5 is the independent contractor law that went into effect in California back in January 1st, 2020. And if you recall, AB5, what AB5 did was require businesses to use a new test to determine if a worker is an independent contractor or an employee. And so that new test is the ABC test. And what that meant was A, is the worker free from control and direction of the hired to perform work, both in under agreement and in actual work. And so ABC is an and test, meaning an employer must satisfy all three of these. Does the worker perform work outside the usual course of the hiring entity's business? B has really been the most difficult to comply with for employers because this has to do with, is that worker performing a service that is integral to what this business does? So an example would be if you have a journalist working for a newspaper can't exist without journalists writing articles. Are they integral to what that business does? Yes. So this has really been the hardest piece for most employers who previously had independent contractors and why they may have transitioned this year to making them employees. And then lastly, C, is the worker customarily engaged in an independently established trade or business of the same nature performed by the hiring entity? That's just a lot of words to say, does this worker have their own business? And are they also performing services with others, for others? Okay, so that's the ABC test. That's just a refresher from last year. And prior to there being an ABC test, there was the previous test that we used for many, many years in California was based on a court case called Borello. And the Borello test was different because it was a balancing test. It was a totality of the circumstances test, where we did have a primary factor, which was really A, does the business exercise or retain the right to exercise control and direction in the manner and means in which the worker performs the work. Then there were all these secondary factors, such as how do they get paid, by the hour or by the project? Is the worker using any of the business's tools or equipment? Where are they doing their work? Again, are they integral to what they do? So there were a lot of secondary factors, and what we employers would do, what I would do in my capacity as an employment attorney for mostly small businesses, is to do this analysis and balance it and determine, okay, is this worker going to be an employer or independent contractor? So we switched out of the Borello test into ABC test for most people, most industries, I should say. But AB5 also had several exemptions by industry and in different categories, where if you've met one of those exemptions, it didn't mean that you automatically could have the worker be an independent contractor. It just meant that you didn't have to use the ABC test. You now were going to use the old Borello test. And so now, as of September 4th, 2020, comes AB 2257 that was signed into law. And it's essentially replacing AB5. The vast majority of AB5 is still in effect. So still the ABC test that remains intact. But what AB 2257 does is it's expanded a little bit. It's provided some more exemptions. It's clarified some pieces. It's defined some areas that were vague and some terms that were vague before. So specifically, some of the changes to note in AB 2257. There's a exemption called business to business exemption. The business to business exemption was actually quite a narrow one because it did not allow the worker to provide services to a business's customers. So, for example, if you think about the typical situation with or the one that they provide in the court case that AB5 was based on, was if you run a retail business and you have a public bathroom in your store and it gets clogged, you call in your plumber. Plumber has their own expertise, their own business. They're coming in for a discrete project, and they come and fix the toilet and then they're out. That would meet their definition of independent contractor. But imagine a situation where you had you're a retail business and you were using an independent contractor to provide styling to your customers. That would not work under AB5, or it specifically wouldn't meet the business to business exemption previously, because then that person that you're bringing in is actually providing a service to that retail business's customers. So this AB 2257 has relaxed that a little bit, allowing now that worker, what they call the business service provider, to provide services directly to the contracting business customers in certain situations. There's still many qualifications for this to work, but it has relaxed it a bit. It also expanded the types of businesses and the referrals under what was called the referral agency exemption, now including things like youth sports coaching, caddying, wedding or event planning, interpreting services. There was also a professional services exemption, which specifically listed many different professions that would be exempt from the ABC test, but again, still under Borello. This adds to that now photographers, photojournalists, videographers, photo editors. It also has an exemption, expands exemption to include master class teachers, appraisers, registered professional foresters, and home inspectors. I know that this is not an exhaustive list, and I know some of these professions are not very big ones. So it's just very interesting to see which businesses, which industries got exemptions, and it really was a matter of a lot of lobbying by a lot of different industries after AB5 was passed. And then it also adds exemptions for certain occupations. And this is where, as I mentioned, it really impacted the music and performing arts sector. So there are certain exemptions for those working in the music sector, certain musicians, certain performing artists, landscape architects, and competition judges. So again, this is just a snapshot of what AB 2257 has done. It's quite broad, and like I said, we could spend an entire hour talking about the changes, but I just wanted to give you a little bit of information there on it. The other question I get quite often is, okay, well, what about Prop 22? I mean, we heard so much, there's so much advertisement about saying yes or saying no to Prop 22 during election time, and as we all know, Prop 22 passed. I just want to be clear that Prop 22 is very narrow, and it really is, as you probably know from the commercials, was driven by Uber and Lyft and DoorDash, because it was those companies that they are app-based transportation and delivery companies who were looking for a carve out from AB5. So unless you are an app-based transportation and delivery company, Prop 22 is not going to impact you. I am very curious to see where this unfolds, because there's been a lot of litigation in this past year brought by app-based transportation companies, where the courts have consistently said that they need to comply with AB5, but now we have Prop 22, which says that they don't. So it'll be interesting just to see how this plays out. Oops. Okay, I just want to go over a few court cases that are of note in 2020. Um, so many court cases. I mean, I know for employers that I talk to, it's so hard to keep up on the constantly evolving number of laws in California in particular that impact them as employers, because that is statutory law, like we just discussed, but there's also case law, which is new law that comes into play because of the result of court case holdings or rulings. And here's just three. There, first, U.S. Supreme Court. In Bostock versus Clayton County. This is back in June. Again, probably heard about this in the news because it was a really big deal. There is a federal anti-discrimination law, Title VII. And what the Supreme Court held here is that Title VII does in fact protect employees from discrimination because of their sexual orientation or their gender identity. That was previously not there. If you are a California employer, this was already a protection in place because California's equivalent to Title VII already included sexual orientation and gender identity, but just now it's also on a federal level. Here is one California Supreme Court case. I'm not sure how to say that, Frecklin versus Apple. And the situation here was hourly workers who worked at the Apple store, like in the mall. And when they exited for the day, so they would clock out and then they would exit, then they would have to wait for a manager who would search their bag to make sure they had not taken anything. And that search could take anywhere from a few minutes to 20 minutes based on the availability of the manager to come search. And so there was a court case here that a class action that said where the employees were saying, wait, I should be paid for that time. I'm working. Or those should count as hours worked. And the court agreed with the employees, saying that they must be paid for that time waiting and undergoing the exit bag searches. What the court's analysis was based on was, yeah, this is hours worked because you were required by Apple to wait there and get your bag searched. It was benefiting the employer. You are still on the employer's premises, and the employer was exercising a significant degree of control over you by making you wait there. And for those who didn't comply, this policy was enforced through a threat of disciplinary measures. So taking all of those things into consideration, the court said, yeah, those are hours worked. And so employees need to get paid. And one thing to note is that this is retroactive, meaning if you previously weren't paying employees for this purpose, now because of this case, they can sue for what was going on before. And then lastly, there's a California Court of Appeals case that came down April 1st, 2020. It's interesting because it was the first time a California court looked at this issue of unlimited vacation. So as you probably know, in California, you're not legally required to give vacation, but if you choose to, the way most employers do is that employees accrue vacation time, and that is considered wages. And so when an employee separates from an employer and they have accrued vacation time, they have to pay it out. So one thing that many employers have done is create something called unlimited vacation policy. So employees are not accruing, and employees can take as much time as they want, theoretically, under this unlimited vacation plan. And so since they're not accruing, it's not wages, when they separate, an employer doesn't have to pay it out. And so in this court case, it was a very narrow holding. It did not decide whether unlimited vacation policies complied with California law. So that still is an untouched area. But what it did hold in this particular case was the way this employer was doing it did not comport with, well, I should say the way the employer was doing it, the court decided that it was actually an accrual basis, and the employer needed to pay this employee out. And just the takeaway on this is what the court said was the reason few reasons why they decided that this actually was accrual was that this employer did not have a written or verbal policy about their unlimited vacation plan. And when they talked about it, they implied that there was a limit on the number of days that one could take. So obviously not being unlimited. So this is a very fact-specific holding, but just for something to keep in mind, if you are an employer that does unlimited vacation plans, put it in writing. Okay, and now just some reminders. Sexual harassment training. So by January 1st, 2021, if you are a California employer with 5 or more employees, you must have provided your employees with who are non-supervisory 1 hour of sexual harassment training. If you and 2 hours for those who are supervisors and managers. This deadline was actually before January 1st, 2020, and it got moved to January 1st, 2021. So just please make sure you're in compliance with that. The DFEH provides free online training. There is the website for that. They have a 1 hour one and a 2 hour one. Other reminder for you is starting January 1st, 2021, there is a minimum wage increase. So non-exempt employees, your hourly employees, if you have 25 employees or less, it is going to be $13 an hour. If you have 26 employees or more, $14 an hour. Now, this is California. A lot of cities have their own minimum wage requirements, which are higher than this. So please note this is just California. Whenever there's an increase with the minimum wage in California, it affects what the minimum salary requirement is for exempt employees. So exempt employees is your opposite of your hourly employees. Hourly employees get paid for hours worked based on that hour. Exempt employees are those who meet certain legal criteria and fall into one of these white collar exemptions, administrative, executive, or professional. And to qualify under an exemption, an employee's job responsibilities need to meet the legal requirements that are quite detailed, but also they need to earn a minimum salary amount. And the minimum salary amount is determined by taking the California's minimum wage and calculating it out for full-time hours and then doubling that. So what that means is if you're classifying someone as exempt, they need to earn, if you're an employer with 25 or more employees, 25 or less, $54,080 starting January 1st. If you are an employer with 26 or more employees, it needs to be at least $58,240. There's also an increase coming for a separate exemption called the computer software professionals exemption. It is now $98,907. They need to earn at least that much. And that's it. I'm going to exit out of here. Oops.
Thank you so much, Shivani, for such a comprehensive presentation. We do have a few questions that had come in, so I'll just go through these now. And Shivani did let us know that she may be able to stay on for a couple extra minutes if needed, but there may be some technical issues. So if that happens, we'll end there, but let's see how many we can get through. So the first question is, if the employer pays the COVID sick and FMLA leave payments, would the employee still collect benefits from workman's comp?
Okay, so not FMLA, I think they meant the FFCRA, which is the Federal Families First Coronavirus Response Act, which has to do with the paid sick leave. So the way that workers' compensation bill is written, it says that an employer must first pay the employee any sort of paid sick leave that is required through just a company policy or state or federal law. So the way that's being interpreted is that, yes, the employer needs to first pay that out. So for paid sick leave, it's up to 80 hours. And if let's say they have a company policy or they additionally have just they're complying with California's paid sick leave law, which is the minimum of the 24 hours of paid sick leave. all that needs to get paid out first by the employer before any of the workers' comp benefits are going to kick in. But also remember with workers' comp, it's not just about, so workers' comp in terms of wage replacement is a partial wage replacement, but workers' comp is more than the partial wage replacement. It's also about medical care and treatment. And so that piece of it might go into effect first under the workers' compensation framework, while they still might be getting paid directly from the employer. And then the wage replacement piece through workers' comp may kick in after.
Thank you. So the next question is, how clear is it that working from home or a home workspace is not the responsibility of the employer, and that the employer is not exposed to liability for conditions in the employee's home? And I think part of this had to do with the question about COVID exposure.
Okay, so I can talk about that in the context of the COVID exposure, but I will generally say if you are an employer who is who now has employees working from home, you do have a certain level of obligation related to, for example, reimbursing that employee for business-related expenses. So if they now need a work computer, or they need internet, or they might need a desk that they didn't have before, most of these things are going to be items that the employer is going to have to reimburse the employee for if the employee spends money on that. But looking at it from the COVID exposure, if we talk about it in the context of that, of the few bills I was talking about today, like the one related to workers' comp, or the one really that one, if we when we talk about exposure at a workplace, that is going to be if you are at a work site that is not your home. I don't know if that answers the person's question, but.
Thank you. So here's a question for SB 1383. How does this work for California-based companies that have remote employees out of state?
Okay, which one was SB? There's the bills I can't tell you by the name. What was that one about?
Hold on, let me pull up. They just referenced that number. So hold on one second.
Oh, CIFRA. It's the CIFRA one.
Okay.
Okay, so it's the California Family Rights Act. So sorry, what's the question?
How does this work for California-based companies that have remote employees out of state?
So it's a very interesting question, and it's one actually that I think is almost a gray area, and there's some colleagues that I've talked about this. So when we say CIFRA applies when there's 5 or more employees for California-based companies. First you look at applicability. Is that going to apply to an employer who might be California-based, but doesn't necessarily have 5 in California, but has 5 all over the place, right? So that's one question that seems a bit unanswered. My interpretation of that is if you are a California-based employer and you have even one California employee, this is going to apply. But of course, you have to have 5 or more elsewhere. In terms of providing that benefit to employees who live in other states, it is not one that a California employer is legally going to have to do. So it's similar to like the pregnancy disability leave. While it applies to California employers, it is a benefit for California employees. If that makes sense. What I have seen though, because I have a lot of clients that have employees in other places, for consistency purposes, most companies will adopt California laws as their default because it tends to be the most generous. And so then there's at least consistency amongst their workforce that, okay, if we have a handful of people in California, they're going to get their 17 1/3 weeks of leave for pregnancy disability leave, or the 12 weeks under CIFRA. And now we have someone in Florida where none of these laws exist. So for consistency, morale, many of the companies, at least that I work with, will adopt it as a company policy, even when it's not legally required, so that they can provide the same benefits to all of their employees. But that's not legally required to, for example, provide it to an employee in a different state.
Thank you. So this next one is a bit of a specific question. It's asking if a 6-employee company has one of the 6 go on leave for 7 months, and that employee was a key employee, and that person, such as a sales manager, and that person is replaced, what does the employer do to rehire the previous sales manager? Does the company now have 2 sales managers, even if only one is needed?
Okay, so I'm assuming when they talk about 7 months of leave, it's because there was a pregnancy and it was a pregnant woman who got pregnancy leave for the 4 months and then took another 3 months for baby bonding. That's the only scenario I'm assuming that's what they're talking about. I could say under both the Pregnancy Disability Leave Act as well as the CIFRA Act, there are extremely strict requirements in terms of reinstatement. So the only way that reinstatement may not occur is if there is an event that would have impacted that employee, even if they were there. So for example, if there was a mass layoff or there was an elimination of that department, and if they were working there, they would have lost their job, then that may be a reason why one is not reinstated. But if you hire someone to cover an employee who's gone out on leave for one of these protected reasons, yeah, you're going to have to figure out a way that that employee who, when they come back, gets the same or similar job.
Thank you.
And I will say, in the pregnancy disability leave regulations that came out many years ago, in regards to reinstatement, there used to be language about undue hardship, like an employer doesn't have to reinstate if it's an undue hardship, and that language is not there anymore. So again, this just reflects how strict of a requirement it is for reinstatement.
So do employers that have 50 or less employees have to provide 2 weeks of paid sick leave time off if it was related to COVID?
Okay, so I think they're talking about the Federal Families First Response Act, that federal law that went into effect back in April of 2020. There were 2 pieces of that. There was the 80 hours or the 2 weeks of paid sick leave for 6 different reasons that were related to COVID. And then separately under that act, there was 12 weeks of leave, which was the expanded family expanded family leave part, which had to do with one thing, which is that you have a child whose school or daycare or childcare center is not open and they're at home and therefore you cannot work. That was related to that. For the federal law that went into effect back in April, that was for all employers with 500 or less employees. The only exemption, the only small business exemption that existed in there had to do with that 12 weeks of the family leave that you could take if you had the child at home. There is not a small business exemption for the 80 hours of paid sick leave portion. And so the new California law that I talked about just now is now applying to employers with 500 or more employees. So now really it applies to all employers.
So for full-time exempt employees, does the $54,080 mean that they are paid a minimum of $26 an hour? Are there any examples of full-time exempt employees that can be paid less than that amount? Where are those guidelines to be found?
Okay, so No, they cannot be paid less than that. And if you are going to classify someone as an exempt employee, meaning they are exempt from overtime and things like, taking your meal break before the 5th hour. And what an exemption means, and when you pay someone by salary, is that they're getting paid the same amount every pay period, regardless of how many hours they work. So you can work a week where you work 6 hours, and then you can work like crazy because you have a project and you're working 60 hours and you're still getting paid the same amount. That is what it means to be salaried. But when we look at if one can be classified legally under one of these exemption categories, again, you look at two things. You look at their job responsibilities, and you do an analysis against what the legal factors are. Those are going to be on the Department of Industrial Relations website. So if you Google like California administrative exemption or California professional exemptions, that would take you to the Department of Industrial Relations webpage where they tell you all the legal factors. I would say do the analysis with an attorney, because while you can read the factors, there's case law informing each of those factors in terms of what it means. So that would be one part of it, to be exempt. One part is you have to meet, that employee needs, their job responsibilities need to meet those legal factors. And the second piece of it is they have to earn a minimum salary amount, which is that like $54,000 or $58,000 I talked about. There is no prorating it for part-time work. So for example, let's say you have someone who just works 20 hours. So the question I've gotten many times is, well, then I could, if I pay them half of that, if they work full-time, they would still be at the 54,000, but they happen to work part-time. But the law actually says it cannot be prorated for a part-time worker. So they need to be earning that full amount at a minimum in order to even be exempt.
Thank you.
And I just want to make a point that in Alameda, the minimum wage is $15 an hour. So that amount would be higher.
Actually, so when you do the exemption under California law, you use California's minimum wage.
Okay.
Yeah, you don't use like the different city.
That's great to know. That's a question that has come up many times.
Yeah.
So we had one question here that was from a business that has only 3 employees, and they were noticing that most of these laws are at least for 5 and over. Is there anything specifically that these smaller businesses with under 5 employees need to be keeping in mind?
Yes, absolutely. So all the wage and hour laws apply. So I'm talking generally, and not necessarily about what I went over today, but I'll say that too. But just generally, all the wage and hour laws apply. Sexual harassment laws apply when you have 1 or more. There's a good amount of leave laws that apply when you have 1 or more. Things like taking leave for jury duty, taking leave for military, taking leave to vote. So there are a good amount of leave laws that can apply. In terms of what I was talking about today, that I had talked about the expansion of the domestic violence, sexual assault, stalking law to now include victims of crimes or abuses. That applies if you have 1 or more, specifically for the employee to go get judicial relief. If you recall, I had distinguished between if you're 25 or more, there's just more reasons you could take protected leave. Since it's come up, that Family First Act, the federal paid sick leave law, that applies. So yeah, certainly a good amount of laws apply.
Quite a few. Yeah. Thank you. So we have, there's 3 more questions in the Q&A, and I think we're going to do these questions and then let Shivani go to be respectful of her time. So is that okay? Do you have time for 3 more?
Yeah.
Okay, great. So what responsibility do employers have for ergonomic support of employees who are mandated by orders to shelter in place? And what if the employer extends work from home mandate beyond shelter in place orders?
Okay, so this goes back to what I mentioned a little bit before in regards to there being an obligation for employers to reimburse or pay for an employee's setup at home. That can vary in terms of what it looks like. So one thing I'll say is that's come up a bunch of times since a lot of people are working from home is, let's say you're working from home. You already had a cell phone and you already had internet, but now you're using those two things for work. Does my employer need to reimburse me? And what the law says is that the employer has to reimburse a reasonable amount. Okay. And that can be calculated in a few different ways. That can be like a percentage. You could just say, I'm going to pay for 25% of your bill. Or you can actually do the math and look and see how often are they using their internet or cell phone for work and calculate it out that way. What most employers that I work with do is give some sort of flat fee every month. But the answer is yes, even if they already have it, but now they're using it for business purposes, cell phone or internet, an employer needs to reimburse on that a reasonable amount. So in terms of ergonomics, I mean, again, it's a little bit tricky because if you have an employee who is having ergonomic issues and they bring it to their attention, an employer's attention, and they need equipment, whether it's like a type of keyboard or a particular type of desk, then there is going to be obligation on the employer. I have a few clients who ended up paying for separate, like private space outside of the home for an employee, so they can have a proper setup, and also where it was a full house and they didn't have any private rooms. The other thing you're going to want to do if you have employees working from home is to have a policy related to that. Talk about having, what kind of business hours are they going to work so that you actually can interact with your employee. Because if they're only working in the middle of the night when you're not working, then it's kind of hard to manage that. Talk about having them designate an area that is for work. Have language about, security and privacy. Like if you are working, this came up with an insurance client. I mean, that's people's private information you might have on the computer. Have a policy that says, this, if it's a business computer, that you're not using it for personal purposes, or you're not lending it to a family member to use it, because then they could see some of this personal or confidential information. So there's definitely a lot of obligations for the employer. It's been a big transition for sure, for employers to kind of figure out, what am I in charge of? What are my obligations when it comes to employees working from home?
Thank you. And so this next one is more about time off. If an employee is working from home and she takes time off because her child's daycare is closed, does that count as vacation time, or is the new federal sick time due to COVID?
So in that federal law, the one from back in April, that situation comes up twice. It comes up under the paid sick leave part. So you can get you can get 80 hours of paid sick leave. If you need to take time off because you have a child under 18 at home because their school is closed or their daycare is closed, and you cannot work as a result of that. It is also in there under that 12-week extended leave. And there are pay requirements under both. It is capped for a certain amount for both of these types of leaves. And then an employer, while they do have to pay them out initially, there is a tax credit that they get. So they're essentially going to get reimbursed kind of through this tax credit. But if an employee is taking a leave for a reason that is protected under those laws, then the first form of payment is going to come under those leave laws, not them using their vacation time.
Okay, thank you. All right, we are on to our last question. Are employers with remote workers prior to COVID obligated to reimburse for work-related, this is sort of similar to, I think, a previous one, obligated to reimburse for work-related expenses as well? Is it up to a certain amount? And is there guidance or resources for information like this?
Yeah, I think we already went over that question. Is there anything different about it that I'm missing?
I don't think so. Nothing I see. Okay. Well, thank you so much, Shivani, for the time that you've taken today. We really appreciate both the presentation and your time with the question and answer. And I will be following up to all the registrants with a recording of this presentation if you'd like to go back and watch it. I also want to give a thank you to Madeline Sadek from the Alameda Chamber of Commerce, who was instrumental in putting this webinar together. So thank you.
Thank you. And I just put in my email and my website. So if anyone needs to get in touch with me, that's my information there. And thank you for having me. And thank you, Madeline, for inviting me.
Thank you, Shivani, so much. You're awesome, as always.
Thank you. All right.
All right. Thank you all.
Okay. Thank you. Bye-bye.
Bye.